Hi guys, thank you so much for tuning in to Battle with Ola. This is Mojola Lua, and on this episode, or let me say, we're starting a short series where we'll be talking about State Council and what they do, what the State Council does. So I'm probably going to title it with what does a State Council even do, or State Council 101. You know, the way we did mediation 101, 102, 103, 104, 105, 106. We're going to be doing State Council 101, 102, probably 103 and 104, as the case may be. Today, State Council 101. It's not necessarily the beginning of the life of a State Council, but it is an integral part. So, who is a State Council? A State Council is a lawyer employed by the government through or attached or posted to or working with the Ministry of Justice of that government. So it could be a state government, it could be the federal government. So once you're employed as a lawyer, to act as a lawyer at a Ministry of Justice, you are a State Council. Yes, you could be employed in another ministry as a lawyer. That does not make you a State Council necessarily. But if you're employed by the Ministry of Justice, whether a state government or a federal government, you are a State Council. And that's what I want to talk about. What does a State Council do? You will understand the basis for this experience if you've been watching the channel for a while. So let's not go into that. But what does a State Council do? A State Council represents the government that employed him or her. So representation could take different forms. In Nigeria, lawyers are called as barristers and solicitors of the Supreme Court of Nigeria. So that means that if you're employed as a State Council, you're also a barrister, and you're still a barrister and solicitor of the Supreme Court of Nigeria. But now you're acting as a barrister and as a solicitor, as an advocate and a solicitor with a Ministry of Justice. So it's not just legal representation in court. A State Council does solicitor work as well. A State Council provides legal advisory. A State Council issues legal advice. A State Council advises the government, just like you have lawyers or retainer or in-house counsel advising their companies and private establishments. A State Council advises the government. A State Council works on legal drafting and parliamentary matters, the making of our laws and the review of laws and amendment of laws. A State Council also works, as you already know, as a mediator, where there's a mediation department or a mediation aspect of the Ministry of Justice. A State Council can also work as a civil litigator. A State Council can work as a prosecutor. These are, the things that State Council do for the ministry or do for the government that employed them, while working at the Ministry of Justice. So we want to talk about, we're going to be focusing in this video. We've talked about the mediation aspect. I'm not certain if all states or if it's existent at the federal level, but some states in Nigeria have a mediation department or a mediation aspect to their Ministry of Justice. So a State Council can work as a mediator in that wise, which is what we talked about at length in the video we did, on the series that we did on mediation. So now this series is going to be focused on what a State Council does as a prosecutor. That is, if you're a State Council working in the Department of Public Prosecution, what exactly do you do? And today we're going to be focusing on bail applications. What does a State Council do regarding bail applications? This is something I've done, and so I'm speaking from experience. Bail applications, we've done a video on bail, an extensive, comprehensive video on bail on this channel. It's about 3 years old. You should go watch it. And several other videos, on such motions as bail. When someone is arrested for an offense and the person has been charged to court or the person's the police has duplicated the person's file to the Department of Public Prosecutions at a Ministry of Justice. The person is probably still going to be held in custody until the Director for Public Prosecution issues an advice based on that file to say that, oh, this person, there's a case against them, we're charging them for this or that, or we are not charging them. So once that happens, the person is still in custody. We are waiting legal advice. Or maybe legal advice is even out and the person has been charged to so and so court, but trial has not commenced or trial is about to commence. The person's lawyer or counsel has the ability or the opportunity to file for their bail application. That will be bail pending trial in most instances. So what we are saying is that, yes, maybe they are going to charge or maybe they are not going to charge. If they are going to charge or if they have charged, we agree they have charged, we will do, this person will stand trial. But pending that, let them be coming from home on some conditions that the court will set. That is bail. Of course, you know that bail involves the lawyer making a case for their client, saying that they are this, they are that, maybe they're first-time offender, or undertaking that they will not jump bail, or the state does not even have a case against them, or these are trumped-up charges the state cannot sustain in trial or on trial, saying all sorts just to convince the court to release their client on bail. So the defense counsel files a bail application on behalf of their client, who is a suspect if legal advice is not out yet. If it's out, who becomes a defendant once they are charged. A bail application could also be filed if you're saying that legal advice is taking time. Is it that the state does not know what they are doing? Release my client. It could also be that, oh, this person is if legal advice is out now and it says that they are not to be charged, ordinarily the court should release the person unconditionally. That means that the state has no case against them, and the person should probably even be considering suing the state or suing the police, for wrongful detention or whatnot. But usually what takes place is that the lawyer, the defense counsel, will now have to come and apply that they be discharged, released unconditionally, proving to the court that legal advice is out and it says they should not be charged. Sometimes some judges will say that, oh, I cannot make that order. Go to the Ministry of Justice, go and get the legal advice that says they should not be charged. Most times you have to pay for that legal advice. You pay something for the legal advice to the state, the coffers of the state. And so some judges are very particular about making money for the state. So they say that even though you're saying they are not charged, or maybe even the state counsel is in court to say, my lord, legal advice is out and this person or persons are not charged, or the state is not charging them, then the court could release unconditionally, which should be the procedure. But sometimes the court will tell the counsel, okay, now that they are not going to be charged, go to the Ministry of Justice, go and get the legal advice, and then take it to the prisons authority to have your client released. But all that, are things that go on. Now, let's focus on the bail application. You're filing a bail application. What does a state counsel do when a bail application has been filed? When a bail application is filed, it is filed on notice. That means you have to put the other party on notice, inform them that I'm filing this application, and serve them a copy. So when the defense counsel files a bail application, they serve the state a copy. That copy is brought by the bailiff to the Ministry of Justice and filed at and given to the registrars or the registry. Usually ministries have central registries, so they collect and they undertake that they have collected, and then that proof of service is taken back to court, filed in the court file, and then they now take it to whoever is handling the file, so that they can respond. So if I'm a state counsel, for instance, what do I do when I receive a bail application? What I do, or what I used to do when I was, working for the Department of Public Prosecution as a state counsel, what I used to do was that I would go and trace the file to start with. I want to know, where's this file? Is it just a bail application, or is there a substantive matter regarding this particular person or set of persons or defendants? If there's a substantive matter, I find out who is handling it in the ministry, which prosecutor, which state counsel or senior state counsel or chief state counsel or principal state counsel or director or assistant director is handling it in the ministry. So when I find that out, I will go and speak to the person. What is going on in your courts? This particular matter, the bail has come to me. It's a substantive matter, you're handling it. What stage is it? And what is going on? Then the person might say that, oh, we are already on trial, we've got so number of witnesses, we're progressing. So then that will let me know how to respond. Because if trial is already ongoing and it's a serious or it's a very grievous offense, and the chances that this person jumping bail may truncate the offense and render the effort of my colleague and the state useless, and interfere with the justice, the way justice is going in that matter, then I will know that I have to oppose this bail application, giving my reasons. Now, bail is at the discretion of the court. That means that the final word to grant or not to grant bail lies with the court. The court has a lot of discretion, a lot of power. When I was in court one day, I told my lord had been going at us. And then I told him, my lord, all power belongs to the court. He was taken aback, because as a pious person outside the precincts of his work, he believed that all power belongs to God. So then, but I noticed there was a change. He soft pedaled a bit, so that he now gave us a chance to actually express ourselves as we should have. But that's on a lighter note. What I'm saying is that the court has a lot of discretion to grant or not to grant a bail application. But when it comes to me, that is what I do. If it's not an ongoing or a substantive matter, then I'll go to the office of the Director of Public Prosecutions to find out, has this file been duplicated from the police to your office? Yes. If it has, what stage is it? An officer will first write it. All state counsel are officers, so that's the generic word. An officer will first write the legal advice. Then another officer, most likely a senior officer, will be sent the advice to vet it. And then the Director of Public Prosecutions will have the final word. And it could be agreeing with what the first officer said, or what the second officer said, or agreeing with both of them in varying degrees. Or you could disagree with them, but everything is based on what the law provides. Because you have to charge based on law. So, no, writing legal advice is based on law, the provisions of the law, under normal circumstances. So if I ask and they say that, oh, we are not charging this person, legal advice is out. When I go to court, I will not oppose the bail application. I will not file a counter affidavit. I will just tell the court, my lord, when the person says that they have an application, we've talked about motions and how to move them a lot. We've overbeaten that topic on this channel. Please watch it. Watch those videos and shorts. So when we say that, when they say that, my lord, we have a motion and we have served the state. When the court calls on the state counsel will say, yes, we have been served. Then the court will ask, what is your reaction? My lord, we are not opposing. Then the court will ask why or on what grounds. Then I can tell the court, my lord, the legal advice is out and the defendant was not charged or were not charged. So it's off our table. They are not charged. What if they have been charged? Or what if there's a substantive matter and I've weighed the options. There are so many things to consider when you're trying to decide if you want to oppose a bail application or not. That is, if you want to file a counter affidavit. You look at the severity of the offense. You look at the proof of evidence. Can it sustain this offense on trial? Is this person a repeat offender? Are they a flight risk? If they are released on bail at this point, what is the assurance that they will keep coming to court so that the case can go on smoothly? Are they not going to impede the will or the course of justice? In fact, another thing that most people don't think about, which is very important, is this bail, the grant of this bail, even good for them? If you have caught someone, for instance, that has committed a very grievous offense, or maybe not so grievous, but an offense that has incited the anger of a community, for instance, and then they are charged to court, and you want them to go on bail, how does it look? They have the constitutional right to liberty, freedom of persons, but they being on bail, is it even safe for them? Are we sure that the members of the community will not take laws into their hands and then do jungle justice if they misconstrue the release as a final release? So you think about a lot of things when you're deciding if you want to oppose a bail application. But the paramount interest of the state, of the court, of the offender or suspect or defendant, and of course that of the complainant too, must be put into consideration. If it's an unrepentant or an unremorseful offender or defendant who is even threatening while in custody that just let me come out, threatening the complainant, that's the nominal complainant, the victim, just let me come out, you will see what I will do for you. In that case, you already know you have to oppose the bill, because if they come out, they'll harm the nominal complainant, who is probably a witness to the state, and then the whole case will shatter, and then the end of justice will be unachievable. So those are some of the things that the State Council considers in responding to a bail application with a counter affidavit. Of course, another primary or important consideration is, what does the law say? In fact, that's the first thing. When I get a file, when I used to, do that, when I get a file, I look at it. Oh, arson. Arson is how many years? 14 years. Is arson bailable? If it's bailable, are they flight risk? Then I consider all the other things. But the first thing I look at, what's the position of the law? Murder. Is murder bailable? In very exceptional circumstances, murder is bailable. Especially, for instance, what most people hide under, that the defendant is terribly ill and needs medical attention, for instance. So I look at it. Is it a bailable offense? What does the law say about this offense? If it's a misdemeanor, for instance, or a simple offense that maybe is 3 years or 2 years imprisonment, it's bailable. So most likely I might not oppose. Or if from the totality of the circumstances, you would know if you're handling the file, and if you've read through the file, you look at what the police wrote, you look at the statement of the defendant or accused defender, we don't call them accused persons now. You look at their statements, what have they said? You can tell what kind of offender are they. Are they sober? Are they remorseful? Will they be a repeat offender? Will they do it again? Are they sorry for their actions? Is this something they have the propensity to repeat? Or you see so many things when you read the file. So the prime thing once you get a bail application is to find the actual file, if it exists, and read up everything in the file. The police case file, and everything that the Ministry of Justice has done after I came to it. If legal advice is out, you read it. If a charge has been filed, you read the charge. Then you look at the proof of evidence. Can we sustain this charge at trial? And so many things. And then you decide, are we filing? You look at the law. What does the law say? Are we filing a counter affidavit? Rape cases, in most cases, you oppose the bail application, because rape is a serious offense. It's a serious offense. Rape is a serious offense. Kidnapping is a serious offense. So when you look at those things, you know if are we opposing or not. So now if you have decided that you want to oppose, the way by which you oppose or the means by which you oppose is by filing what is called a counter affidavit. A counter affidavit is your own response to the motion for bail, motion for release of the offender or the suspect or the defendant as filed by their lawyer. What will your affidavit contain? Your counter affidavit, then your written address. Those two things, you file it. They will file motion for bail, affidavit in support, and written address. But you are going to just file a response in terms of counter to their affidavit and then your own written address. In your counter to their affidavit, you tell us who you are. It's usually deposed to by somebody in the department, not necessarily the counsel. So you tell us who that person is, yes, and then they will now set out the facts countering what they have said, because normally in the bail application, in the affidavit in support, affidavit contains statement of facts, so it doesn't contain opinion or decided cases, judicial precedent. So basically in a typical bail application, affidavit is saying that, oh, this person, maybe the person's wife or husband or relative, that's the defendant's, will swear depose to their affidavit stating that I'm so person, I live as so, I'm a Christian, I'm a Muslim, I am so and so person, religion, where they live, what they do for a living, if necessary, their age, their sex, some nationality, those things, and then they will now say that I verily believe these things I'm about to say to be true, that is, I'm saying the truth. This person is an honest Nigerian. They go about their jobs. They don't know anything about this matter. In fact, on the day when they were arrested, they were at so place, and then they were arrested. This is all a misconstruence. This is not. They have never done this kind of thing. They are not going to do it. They are this, they are that. Basically facts about them, countering what the state has said that they are charging them for, what they are doing, what the police has said. Now, in your own counter affidavit, after you have stated who you are and on the authority, on whose authority you are deposing to the affidavit, and you're telling us these things, you tell us, usually the state counsel will prepare it, but he or she will find a deponent within the department. It could be an admin officer. Most times an admin officer is used, a clerical officer within the department who will depose to the affidavit, a litigation clerk most likely, saying that, oh, contrary to what this person said, they have said that they were at so place, they've never done this, they've never done that. This person has done this before. In fact, the police statement that they wrote with their own hand states in paragraph so that so you say what they have said to show that they've done it before, or they will do it again, or they're actually guilty. You're trying to establish a basis for asking the court not to release them based on facts. So you say, from the police case file that we got, this and this and this are the things that are there. Yes, this and this and these are the things that the person has done or has said. So this. Then in the ending paragraphs, you tell the court that you believe that not granting it will not impede justice. It is in the interest of of justice, and then it will not do them any harm. It will not compromise the case. You convince the court otherwise, because the other person is trying to convince the court to release them. So you convince the court not to release them. Yes, let me read some portions of a counter affidavit to you. I, John Bellion, male, Christian, a clerk in the Ministry of Justice Secretariat, the state, do hereby make an oath and state as follows. 1. That I am a clerk in the Department of Public Prosecutions of the Ministry of Justice, so state, that by virtue of my position I am conversant with the facts of this case, and I have the consent and authority of the applicant to depose to this affidavit. The state is the applicant, And I have the consent and authority of the respondent to depose to this affidavit. The state is the respondent. that I have seen and read the applicant's summons for bail and the supporting affidavit. That's what the defense counsel filed. That paragraphs 1 and 2 of the applicant's affidavit are facts within the knowledge of the deponent. So that means we are not disputing those facts. Usually they are innocuous facts, They are, they are probably facts about the name, the age, particulars that are not in dispute. Then you go on that paragraph 3 of the applicant's affidavit is true. So you tell us what you agree with and what you disagree with as a state counsel in an affidavit. That paragraphs 4, 5, and 6 of the applicant's affidavit are false. So after saying they are false, you have to tell us what the true position is. You don't just say they are false. The next paragraph, that contrary to paragraph 6 of the affidavit in support of the applicant's summons for bail, I was informed by O.M. Livingstones, the Chief State Counsel handling this case, and I verily believe her as follows. This is just a sample, it's not real. Then when you get to that kind of paragraph, the things that you state under it, you don't make them independent paragraphs, you make them sub-paragraphs. This is paragraph 7. So 7A will say that the applicant was arrested on the 3rd day of April 2021 at Area Command Office at so place. You mentioned the location at about 12:30 hours. That's how policemen write their hours. So 7B, that the applicant's car had already been damaged before he escaped and went to the area command office to report the incidents. 7C, that it was the applicant who provided the gun he alleged to have collected from somebody when he returned to disclose the number. Per case, you would understand the facts. So you're setting out facts, to counter what they have said in their affidavit. So I don't want to go into too much details, but just to give you an idea of what it is about. Then the next paragraph, that's that the applicant confessed to the crime. That's another paragraph. Now you've left 7. Confessed to the crime throughout the course of investigation and even narrated his previous criminal activities and also mentioned his gang members' names. A copy of the applicant's confessional statement is attached as Exhibit A and B. So you know what I said, you refer to the police case file, and then you now attach, when you're filing this counter affidavit, you attach the statements that you refer to as exhibits. So Exhibit A and B in this instance. Then paragraph 9, that the applicant confessed that he has a pending robbery case in the High Court number 10, location of court. That the applicant said he was just released on bail in the said armed robbery case on Thursday, 24th of June, 2020. This is establishing the fact that he's a repeat offender and it's dangerous to let him go on bail, because he will just go and commit another crime. Then that the applicant said he was just released on bail. Okay, no, I said that. So now he's on bail. If you give him another bail, he will go and commit another crime. So he's a serial offender. And these things are things that the judge can confirm in the record before the court. Because as you have the police case file and all this, the judge will also have the things that you intend to use, the things that the other party intends to use to defend themselves. So these things must be before the court, So you're not just saying this in thin air. And when you say that they were released on bail, the court can easily go and confirm from its sister court, is this person on bail from your court? But of course, you have to support these things with exhibits, especially if it's a document that you've referred to that is not yet before the court. But if it's before the court, you're home and dry. In some instances, if it's before the court already, you have to put proof. There was a case, I think I mentioned it on this channel, that I was opposing the bail application, and then I was saying that, the case, the substantive matter is going on in court so before my lord's learned brother. And then the defense, the court could have let it slide, but then the defense opposed and said that I was just speaking into thin air. There's no proof before this court that such a thing is going on. There's no proof that there's a charge against his his client, and that the case has been opened or anything. So the court now turned to me that why didn't I attach a proof with my counter affidavit? Then I asked for a date to do the needful, So in an extreme case, the court could have, granted the bail because I was just saying it. I did not support it, even though it's something the court could have confirmed. But the court is very busy doing other things. So things that you think, the court should be able to confirm this, just put it there for them. Let them see it. So I then came back at another date, having filed, another counter affidavit where I now attached the charge that was before my Lord's learned brother, where the case was ongoing. And then I brought other facts, to prove to the court that the case is actually ongoing. So it is not expedient to release him on bail in this court when he's already standing trial for this particular offense in that court. Or let's just move the bail to that court. So if that court thinks that releasing him will not affect the ongoing trial, let them release. And if they think otherwise, to fine. So that's what happened in that case. Then you now go to, those are facts you stated. Then you now go to the closing paragraphs where you say that 11, that due to the gravity of the offense and the evidence already before the court, the applicants will jump bail if granted. You most likely always have to put that in your counter as a state counsel, because they are also vouching, for their own client. So you have to say that. And it is not an opinion in this instance, because you are referring to what is before the court, what the court can confirm, that on the basis, on this premise, our conclusion is that it will jump bail. Don't grant it. Then 12, that the interest of justice will be better served if the applicant's application is refused. Then 13, that I swear to this counter affidavit in good faith and in accordance with the oath law. You put the year of the oath law and then all the other things that are contained in the counter affidavit. Then you attach a written address. In your written address, you set out issues for determination and you defend them with judicial precedence, just like any written address. So here, issue for determination is that whether the applicant has placed enough material before this honorable court to warrant an exercise of his lordship's discretion in his favor, because he's asking for bail. Has it proven to the court that this bail should be granted, that this discretion, bail is discretionary, should be exercised in his favor? And then we go on to our argument where we cite a lot of cases. There are so many cases in support of bail applications in Nigeria. In fact, some cases are so rehashed that tap any state council, they know what to put. And then there are some innovations, when you want to do extra research. For instance, like Atiko and the State, Likita and COP, Bamaye and the State, Ajido and FRN. Those are cases that are, good for counter affidavits. So you set out your legal arguments. How do you do it? You start by laying out what the court has decided in several cases as considerations for the grant of bail application. So what are these considerations that you put before the court? It's been decided in a plethora of cases that to grant bail application, the court will look at these things. Then you now put support that, the court, if you look at this in this instance, it cannot work. If you look at this in this instance, they cannot prove it. If you look at this in this instance, they cannot do it. So they are that the nature of the offense, the severity of the punishment, the evidence available against the defendants or accused persons, and the probability of guilt. Those are things, that a court must put into consideration. Then you espouse on each of those 4 points. As to the nature of the offense, you tell the court, this is murder. It is a grievous, serious offense. Then as to the severity of punishment, this is murder, my lord. It's punishable by death. As to the evidence available against the accused persons, that's when you make reference to, the evidence available. What has been put together in the duplicate case file. Then the last one is the probability of guilt from the totality of what is in the case file. this person is likely guilty, and you're not deciding for the court, but you're suggesting or telling the court that if you look at this thing very well, so in your original address, even though you are not deciding for the court, you can make inferences. You can refer to the statement of the accused person that you have cited in your affidavit, that from the statements, this person, is likely guilty. So that's the third point. Then the fourth point is this person may, interfere with justice. They may. It is better if you exercise your discretion against them by not granting them the bail, because, for instance, if you can interpret the accused person or defendant's statement such that they will likely compromise our witnesses if they are released on bail. The nominal complainant may be in danger if they are released on bail, and you are tying everything back to what is before the court. No wishful thinking here, and you cannot decide for the court, so your opinion is not needed. But you can make inferences from what is before the court, and then you conclude by asking the court to exercise its discretion against the applicant by not granting the bail application. So many things you can do. So, but this is basically how to do a counter affidavit. Then you file it, you serve the other party as well, and then both of you will move your applications before the court. The court will decide. The court may give you a date to come back for the ruling, and that does not affect an ongoing case. If a case is already ongoing, the bail can be going on separately and the case will be going on separately. So if the person is to be released on bail, the person will be released, but they will still be coming for the trial. And if they are not to be released, the trial will just go on, or whatever is going on will just go on. So this is what a counter affidavit is. What does a state counsel do? A state counsel files counter affidavits. A state counsel opposes bail application. So that's all I have for you in this video. I will see you in my very next video. Don't forget to subscribe. To-dos. It's also important for any bail applicant, to know that it is not personal to the state counsel. This is just how things work, and this is what is needed or needful, for a sane and orderly society. So no hard feelings, but this is one of the things that a state counsel does. I will see you in my very next. I no longer do that, but I used to, and I've done it. So that's why I'm providing this experiential view. I will see you in my very next video. Don't forget to subscribe. Don't forget to book a paid consultation if you need to discuss further on any legal challenge, where I prefer legal solutions to that challenge for you. And if you need any other legal service, don't forget to contact me. Check the description box for how you can do this, or just mail me at houseoflivingstones@gmail.com. I will see you in my very next video live session. Bring someone on the channel. To-dos.